This video, while not legal advice, highlights several key differences between the EU's GDPR and Brazil's LGPD data protection law. Let's start with the appointment of data protection officers, or DPOs. The GDPR requires mandatory appointment of a DPO for public authorities, organizations that engage in large-scale and systematic monitoring, or organizations that process large-scale data relating to criminal convictions and offenses, or special categories of data. Brazil's LGPD requires the appointment of a DPO without specifying the scale or the type of processing. Also, each controller under the LGPD can determine their own requirements for a DPO. Next, supervisory authorities. Each EU member state has its own data protection authority responsible for enforcing the GDPR, leading to some variations in enforcement. Brazil has a central body responsible for enforcing the LGPD across Brazil. Third are the legal bases for processing. The GDPR establishes a detailed list of lawful bases for data processing. Similar to the GDPR, the LGPD also requires a legal basis for processing personal data. However, it includes 10 specific legal bases, which, in addition to those similar to the GDPR, also includes the protection of credit. Fourth are DPIAs. The GDPR states that DPIAs required in specific processing circumstances. In some extremely risky cases, the GDPR requires a prior consultation with a supervisory authority prior to processing. The LGPD does not specify when a DPIA is required, but the regulator can request the controller to perform a DPIA. DPIAs under the LGPD have slightly different requirements than the GDPR. There is no prior consultation requirement in Brazil. Fifth are data breach notifications. The GDPR requires notification of a data breach to the supervisory authority within 72 hours of becoming aware of it, unless the breach is unlikely to result in a risk to the rights and freedoms of individuals. The LGPD also requires data breach notification, but does not specify a strict time frame. It must be done within a reasonable time period, as determined by the regulator. Lastly are fines and penalties. Penalties for GDPR noncompliance can reach up to 4% of annual global turnover, or 20 million euros, whichever is higher. Under the LGPD, the fines can go up to 2% of revenues in Brazil, up to a total of 50 million reals per infraction. Both regulations share the goal of protecting personal data and empowering individuals with rights over their data, regardless of where stored or processed. However, the provisions and enforcement mechanisms differ, reflecting the distinct legal and cultural contexts in which they operate. Compliance with both requires a nuanced understanding of the differences and a tailored approach in practice. Please visit our website at governisto.com for more information or to sign up to our weekly newsletter, or, if you prefer, follow Governisto on LinkedIn, YouTube, X, and Instagram.